Some of what you believe about carrying a firearm legally will cost you your permit. Some will cost you your freedom for years, and a few will put you in a courtroom while a prosecutor reads your own decisions back to you as evidence. I'm going through 5 of them. One of these turns a routine traffic stop into a felony arrest in 14 states, and most carriers have no idea the law even exists. And number 1 is the most repeated mistake in concealed carry, and it's the one most likely to send a law-abiding person to prison. I brought the actual statutes, the real convictions, and the legal standards that decide what happens after you draw. Not opinions, and they get more dangerous as we count down. Number 5. Your carry permit works everywhere you go. This is the belief that gets good people arrested at traffic stops. They assume their license travels like a driver's license, honored everywhere, recognized by any officer, no questions asked. It doesn't work that way. There is no national concealed carry reciprocity law. Every state writes its own rules. Some honor your permit, some honor it from specific states only, and a handful honor nothing from outside their borders. Cross into New Jersey with a valid Texas permit. Your permit means nothing. Carrying in New Jersey without a state-issued license is a second-degree felony, up to 10 years in state prison. Cross into New York with a Utah permit. Same outcome. Criminal possession of a weapon in the second degree is a Class D felony, up to 7 years. Maryland, California, Hawaii, Illinois, Massachusetts, Oregon, Rhode Island. These states have either no reciprocity or lists so narrow that most out-of-state permits don't qualify. You can drive through 3 states in a single afternoon and be legally armed in 2 of them and a felon in the 3rd without touching anything in your car differently. The error is the assumption. It feels like your permit should work because you earned it, because it's government issued, because you did everything right. The law doesn't reward that feeling. It enforces the statute. Before you travel with a firearm, look up the reciprocity rules for every state on your route. State attorneys general publish these tables. Check them. Laws change. A Florida permit holder was stopped for a broken taillight in New Jersey. He answered every question honestly. He was still handcuffed. His permit was valid. His carry was not. Number 4. You know which places are off limits. You probably know the obvious ones: a courthouse, an airport past security. The problem is, the list extends well beyond what most carriers picture, and stepping inside the wrong building for 30 seconds can be a federal felony. The Gun-Free School Zones Act is a federal law. 18 United States Code, Section 922. It creates a 1,000-foot buffer zone around every K-12 school in the country. Step inside that zone while carrying without a valid state-issued permit exemption, and you've committed a federal offense carrying up to 5 years in federal prison. 1,000 feet is roughly 3 city blocks. In a dense neighborhood, you can pass through that zone without approaching the school, without a marker, without a sign. Post offices. You cannot carry inside a United States post office. Federal property. Federal regulation, it applies regardless of state law or the permit in your wallet. Federal courthouses, VA medical facilities, any building owned or leased by the federal government. Many states add their own layers on top. College campuses in most states, polling locations on Election Day, establishments whose primary revenue comes from alcohol sales, depending on the state. None of these locations carry a warning that applies to you specifically. A community center running a licensed preschool in 2 of its rooms might place the rest of the building inside a school zone. An office leased on the ground floor of a federal building can trigger prohibitions on every floor above it. Ignorance is not a defense. Courts have upheld this for decades. Know the prohibited zones in your state. Know the federal ones. If you regularly drive a route near a school, look up the perimeter. The law does not care that you didn't know it existed. Number 3, you don't have to volunteer that you're carrying. In most states, that is correct. In 14 of them, it is a crime. Ohio, Texas, Michigan, North Carolina, Arkansas, Louisiana, Nebraska, Nevada, Oklahoma, and several others have mandatory duty to inform statutes. The requirement is not complicated. If you are lawfully stopped or detained by a law enforcement officer, you must tell them immediately that you have a concealed firearm on your person. Not when they ask, not when the conversation reaches it. Immediately. In Ohio, failure to inform is a second-degree misdemeanor on the first offense. In Texas, it's a Class A misdemeanor, the same category as assault causing bodily injury. Here is where this catches carriers. A driver from Georgia, a state with no duty to inform, takes a 3-day trip into Ohio. He gets stopped for speeding. He says nothing about the firearm because he never has before, and nothing in his training told him to. He has just committed a crime in a state he was visiting for 72 hours. He will probably find out when the officer finds the gun. There is also the practical reality. Officers who are told about a firearm at the start of a stop respond differently than officers who discover one mid-search. The disclosure that costs you nothing at the window can keep the entire encounter from turning into something it doesn't need to be. 2 left. And these are where the charges stop being misdemeanors and start being years in a cell. Get subscribed because the last 2 decide whether you go home. Number 2, drawing your weapon ends the confrontation. Sometimes it does. But drawing a firearm when the legal threshold hasn't been met doesn't end a confrontation. It creates a new legal problem for you. The threshold exists in every state, worded differently, but requiring the same thing: a reasonable belief that you or someone else faced imminent threat of death or great bodily harm. Imminent. Not possible. Not anticipated. Happening right now, and lethal if it continues. A driver in Virginia was followed by an aggressive tailgater into a parking lot. An argument followed. The other man showed no weapon. There was no physical contact. The driver drew his firearm to end it. He was charged with brandishing a firearm in a public place. A Class 1 misdemeanor in Virginia. Had a child been present in that lot, it becomes a felony. He believed he was responding to a threat. The law measured that belief against the facts at the moment he drew. The facts did not support imminent deadly force. Here is the part that most training skips. The legal standard for drawing and the legal standard for firing are the same. You need identical justification to pull the gun from the holster that you need to pull the trigger. If you draw and don't shoot because the situation de-escalated, you may have still committed brandishing because at the moment you drew, the standard wasn't met. A holstered firearm is a tool. A drawn firearm without legal basis is an assault charge. The courtroom will not ask whether you were scared. It will ask whether a reasonable person in your exact position would have had genuine cause to fear imminent death or serious bodily harm. If the answer is no, the charge stands regardless of what you believed in that parking lot. 1 left. And this is the one that puts carriers in prison for years. Subscribe before I give it to you. Number 1, if you shoot in self-defense, the law is on your side. If the shooting was legally justified, yes. If it wasn't, the law is the reason you're sitting at a defense table. Justified use of deadly force requires 4 things, and you need all 4. The threat must be imminent, not yesterday, not in 5 minutes, but happening right now. It must be reasonable. An objective person in your position would have genuinely feared death or great bodily harm. It must be proportionate. Deadly force can only be used to stop deadly force. And in states without stand-your-ground protection, it must follow an attempt to safely retreat if retreat was possible. Roughly 12 states retain a legal duty to retreat. New York, Massachusetts, New Jersey, Connecticut, Maryland, Delaware, Hawaii, Maine, Rhode Island, Nebraska. In those states, using deadly force when you could have safely escaped can result in a manslaughter or second-degree murder charge, even if the threat was real. In Stand Your Ground states, there is no retreat requirement, but Stand Your Ground removes one element. The other three still apply. Shooting a person who is running away. The threat is no longer imminent. Shooting after the physical confrontation has already ended. Same problem. Using deadly force to protect property and not a life. Not legally justified under any state's deadly force statute. Being the initial aggressor in an altercation, and then using deadly force when the other person fights back. The aggressor exception removes your self-defense claim in most states. Manslaughter convictions in these situations carry 5 to 15 years, depending on the state. Second-degree murder charges carry 25 or more. These are not outcomes that happen only to reckless people. They happen to people who use their firearm believing they were justified and were wrong about the law. The test is not whether you were afraid. It is whether your fear was reasonable, whether the threat was imminent, and whether you had exhausted the option to retreat before that moment arrived. A prosecutor will take every detail of what happened before the shot and walk a jury through it, piece by piece. The gun is the tool. The law is what determines whether using it protects you or convicts you. Knowing the difference before you carry is not optional if you intend to walk out of court the same way you walked in. So there are your 5. Notice how they run. The reciprocity and prohibited location mistakes put you in handcuffs before you ever drew. The failure to inform adds charges to a stop that never needed to go that way. And the last 2, drawing without legal basis, firing without meeting the standard, those are the ones that show up in sentencing hearings. Every one of these has put a law-abiding carrier in front of a judge. Tell me below, which one of these surprised you the most? And is there a state-specific law that's caught people you know off guard? Subscribe, because the next video covers what to do and what not to say in the minutes immediately after a defensive shooting. And that window is where most people make it worse.